Good morning, everyone. This is Brittany from the Kentucky CASA Network. It looks like we have 17 people on the webinar right now. If you can just type in your first and last name and your program into the chat, that way I can make sure that I have everyone. We're about to have Duane on the call. Duane is going to be leading this presentation, and if you have any questions for him, probably the best way of going about this would be to type your question into the chat and make sure it's either sent directly to me or to everyone. And then we can, once he goes through the presentation, we'll be able to answer those at the end. So we're just waiting for Duane to call in here, and then we can go ahead and get started. Duane, are you there?
I'm here now. Somebody just unmuted me.
That would be me.
Can you hear me?
Yes, we can hear you.
Ah, okay. All right, Della, I think we got it. Thank you.
Okay, great.
Yeah, I don't know what was going on there, but I couldn't fix it. So.
No worries. Anyway. I think that we're good now, and I've told everyone that we're going to go ahead and you'll go through the presentation, and if they have questions for you, they're going to type them in to the chat area, and we'll get to those at the end. I'll be tracking those to see, and then Della, if you can also just keep an eye on those to see if there's any that I've missed. But other than that, I think we're ready to get started.
Okay. Hey, everyone. I'm Duane Osborne, and I'm an attorney in Lexington. And I've been working with CASA since I started doing stuff in DNA court, dependency, neglect, abuse, back in 1993. So that tells you that I'm old. In addition, I wrote the guardian ad litem training curriculum in the state of Kentucky, and I've spent 20 years going from county to county to teach guardian ad litems how to do that type of work. Now, if you've had bad guardian ad litems, please don't make that think negatively of me. I tried, is all I can say. We have a lot of difference in quality in guardian ad litems throughout the state. But I was asked by the folks here to talk about the roles and the relationships of guardian ad litems and CASAs in Kentucky. So we put together a little presentation, and next slide, please. And here's what the goals are. I'm going to discuss, and I welcome questions at any time. Anytime someone wants to ask a question, please do so. And I can't see that chat box on my screen, by the way, so if you know that there's a question, just let me know. I have to actually keep a cursor over it in order to see that there's a question. But we want to talk about the differences between what a court-appointed special advocate is and what a guardian ad litem is. And that's actually literally just changed in the last couple of years. Also, I'm not going to spend a lot of time on whether CASA reports are hearsay, because they're not hearsay. They may contain hearsay, but then again, so might cabinet reports contain hearsay. But don't worry, there's a statute that says that you all need to provide the court with a report. So I think you're covered there. Also, I was going to discuss whether the prosecutor represents the cabinet, or do they represent someone else? I was going to discuss a possible immunity. As long as you act in good faith, I feel real satisfied that any CASA would be immune from civil or criminal litigation, which is a good thing. And I thought I'd provide a couple of tips of how to be a more effective CASA, how you can work better with a guardian ad litem and maybe other court or community partners. So that's our altruistic goals for this morning. We'll see how we do. Next slide, please. All right, and the first thing that we'll talk about are what are the main differences between a court-appointed CASA and a court-appointed guardian ad litem. Next slide, please. Whoop, got to go back one. There's a lot of differences. CASAs absolutely have a right to be, statutorily have a right to be involved in DNA cases that they're appointed on in Kentucky. But in every case where there's an abused or neglected child, or a child may end up abused or neglected, the the Supreme Court and actually federal law requires that there has to be a guardian ad litem. And I've heard horror stories going from all throughout the state. I have personally witnessed counties where they don't appoint guardian ad litems for every case. There's not an asterisk in that federal statute, which by the way is part of CAPTA. They're supposed to have a guardian ad litem, and a guardian ad litem in Kentucky has to be an attorney. In a lot of states, a guardian ad litem does not have to be an attorney. But in Kentucky, we have guardian ad litems who have to be attorneys, and often we have court-appointed special advocates who occasionally are attorneys but don't have to be attorneys. Both CASAs and guardian ad litems, of course, they have the same goal, and that is to advocate for what is in the best interest of the child. A main difference between a guardian ad litem and a CASA is the child is the guardian ad litem's client, in a legal sense. In a legal sense, CASAs do not represent the child. So that's a main difference. And as a result of that, guardian ad litems have the right to call witnesses, to cross-examine witnesses, to take direct testimony or cross-examination of anyone who the cabinet or the prosecution or a parent were to call, whereas CASAs do not have the right to cross-examine witnesses. And I remember many times I've had some great CASAs throughout the time. I remember being in a hearing once with one of our more active CASAs who had my cell phone, and during the case, she actually texted me some questions that she thought that I ought to ask, which kind of made me laugh. I think I used a couple of her questions, to be honest with you. But generally, you're not able to ask questions unless you know somebody's phone number that you can text them to, I guess. But this case of Morgan versus Getter, which you may or may not have heard of, it changed the way guardian ad litems are supposed to do work. And I've done some follow-up training on this particular case. I spoke at the judges conference in Louisville earlier this year, and it's pretty obvious that we do not have a unified system yet of how this is working out. But Morgan versus Getter involved a guardian ad litem, not in a DNA case, although I'm going to tie it to DNA. It was a highly contested. It was a civil action. It was a post-divorce deal where a father and mother had two daughters. One actually aged out and went to live with dad, who was a truck driver who moved from northern Kentucky to Florida. And the 16-year-old sister wanted to go with dad as well. The judge in that particular case appointed a guardian ad litem. You don't have to have a guardian ad litem in divorce or custody cases, as you do in every divorce, every DNA case, or every termination of parental rights case, or almost every adoption case. But in custody cases, you do have to. You don't have to, but you can. So this judge appointed a guardian ad litem who was an attorney who they wanted to investigate the situation and to make recommendations to the judge as to what was in the child's best interest. The mother's attorney in that case wanted to cross-examine the guardian ad litem, and the judge said, no, you can't do that. And that's how this case ended up causing all hell to break loose. Because at that point, in fact, we had 8 trainings scheduled to do parents' attorneys trainings on DNA court in the state of Kentucky. You guys were going to be invited, and then we got a call from Justice Noble. At the time, it was a Supreme Court justice who said, stop those trainings. We just accepted this case, Morgan versus Getter, and it's going to explain what guardian ad litems do and what they're supposed to do. And as a result, we want you to add that to your parents' training, and we'll just do it later. Well, as fate would have it, they never had the money to continue to do those trainings, so we never had that training. But this case was decided, and here's what they said. Next slide, please. And there you go. They said that there's a lot of differences between guardian ad litems and, in this case, what they called friends of the court. And you guys are closer to a friend of the court. In fact, I believe that Della says that's what the model that you guys, that National CASA uses is a friend of the court model. Certainly makes sense to me. But here's what Morgan versus Getter, the Supreme Court, said, that both of these entities, whether you're a guardian ad litem or a friend of the court, which I would say FOC or CASA, you have to advocate for what's in the best interest of the child. And they extended that to DNA cases and TPR cases as well. Next slide. Next slide, please. Thank you. So specifically, here's what the statute says that your CASA volunteers need to do, and I think probably all of you guys know this, that you're to attend all court hearings, to submit written reports and recommendations consistent with the child's best interest, monitor and visit the child, participate in treatment planning conferences, interview parties, and remain actively involved with the child's case until dismissed. Interestingly, this is exactly what we would teach guardian ad litems that they're supposed to do. However, my experience was the CASA volunteers were a lot more likely to do all of this than guardian ad litems were. Your results may vary. Oh, do we have I'm sorry, now I see the chat down here. Do we have some, let's see. Okay. Sorry, I see a chat, but I don't see any questions there. So let me move on. Anyway, I wish guardian ad litems did all of these things, but of course they don't necessarily. All right, next page, please. All right, and the statute, and this is the statute the Supreme Court picked up on. They said the duties of the guardian ad litem is to advocate for the client's best interest in the proceeding through which the guardian ad litem was appointed. And they distinguished this, that advocating for the client's best interest versus the child's wishes. Believe it or not, and I know that this is going to probably stun a few people, we get counted off nationally every year because our guardian ad litems don't advocate for the child's expressed wishes, and in fact, we advocate for the child's for the best interest of the child. And they went through this Morgan versus Getter is a 52-page opinion, and they spent 10 pages talking about how they know other states advocate for what's in the best interest or the express wishes of the child, but they don't believe that that needs to be done. In any event, under, at least in DNA court at this point, but they did say that there is some reason that at some point you may have to have a friend of the court and a guardian ad litem in cases that are not DNA cases at this point. The only reason I'm even talking about this is there's no question that what's happening here with guardian ad litems in front of the courts is going to be moving into the DNA case. It's going to take a case on appeal. Someone's going to have to appeal a case saying, hey, what we do statewide for guardian ad litems and not having front of the courts, unless you call them CASAs, in DNA cases is not consistent with what the Supreme Court said. Eventually, I think that's going to change. But in any event, we have to the people at the American Bar Association for the children in the law desperately want us to not advocate for kids' best interests, but to advocate for their express wishes. I'm glad I would tell some funny stories about that when I do my training, but thank God we don't do that. Next slide, please. So here's what Morgan versus Getter said in that particular case. They said in highly contested custody cases, the court will naturally want the advice of someone like a friend of the court, someone who's authorized to investigate independently the custodial situation and report back to the court. Some children may require an independent advocate, however, a guardian ad litem, an unbiased adult who can explain the process to the child, convey to the court the child's wishes, make motions, and introduce evidence. In those cases, you have to have a guardian ad litem because a friend of the court cannot make motions or introduce evidence. So next slide, please. So the Supreme Court also said, like a friend of the court or a CASA investigator, the guardian should undertake a thorough examination of the circumstances. Unlike the friend of the court or CASA, the guardian ad litem is the child's agent or attorney, and the guardian can make motions, introduce evidence, advance evidence-based arguments on the child's behalf. Those are all things that CASA cannot do. You can make recommendations in your report, which is, in a sense, advocating for a child's best interest, which is what you need to do, and that's what the statute says. But the Supreme Court says you can't make evidence-based arguments on the child's behalf or make motions or introduce evidence. And it said, unlike the friend of the court or CASA, the guardian ad litem should not file reports, which, by the way, in our DNA court in Fayette County, we have 4 judges, 4 family court judges. When this court came out, half of our judges said we no longer can do guardian ad litem reports in DNA cases, and half of them said we don't care until they specifically tell us we can't have those in DNA court. Keep doing them. And I realize that you may be scratching your head thinking, what guardian ad litems do reports in DNA cases? Well, we've done them in Fayette County for 20 years, and I know a lot of other counties, some of the judges require the guardians to do reports. In any event, it said the guardian should not file reports, testify, make recommendations, or put the credibility in issue. As a CASA, however, you absolutely can testify. And I've called CASAs to testify before. Most of the time, something happened during a visitation that they were observing, to be honest with you. But absolutely, CASAs can testify. Friend of the courts can testify, but guardian ad litems cannot. Next page. All right, just going to spend a minute on this, but our CASA reports hearsay. And next page, please. Basically, I mean, the definition of hearsay is an out-of-court statement that was offered to prove the truth of the matter asserted. You could spend 2 hours a day, 5 days a week for a year in law school going over all the exceptions to the hearsay. The only ones that you need to realize, I mean, here's the thing. There's a statute that says that CASAs need to file a report with the court. And that's great. That you need to file a report with the court. Whether, first of all, are CASA reports hearsay? That's not well worded. Do CASA reports contain some hearsay? That answer very well is probably yes. But is it permissible hearsay? Because there's a bunch of people think hearsay, they think, oh, it's automatically wrong. No, there's a lot of hearsay that's admissible. For instance, anything the parents tell you is admissible hearsay. So I guess what I would say is I wouldn't worry about whether hearsay is in your report. Just do your reports, do the best you can, advocate for the best interest of the child, and let the attorneys figure out whether your report is, it contains some hearsay or not. To be honest with you, I don't think I had a few times people wanted to get rid of a CASA report, and I don't think any of our judges ever dismissed the CASA report. So that's good. All right, let's moving on to the next one. And that is our court-appointed special advocates a party in a DNA case? I know when I was doing, next slide, please. I remember when I was doing the guardian ad litem training, and we did, at our peak, we did about one a month. So there was a lot of counties we were going to. And I remember getting a call from the administrative office of the court saying, you need to emphasize in your training a couple of things. One is that foster parents have a right to notice and to be heard, and also CASAs are not parties, but they have a right to notice and to be heard. So I'm not sure what exactly that means, but here you go. Technically, I do know this. CASAs are not parties. The parties in a dependence and neglect abuse case are the parent, any parent or anyone who's exercising custodial control or supervision, the child is a party, and the Commonwealth of Kentucky is a party. So people think that the cabinet's a party, but more on that in just a minute. The cabinet has a job to do, and they also have counsel. But regardless, CASAs are not allowed to ask questions of parents or parties or witnesses outside of court. Now, realize you can absolutely speak to parents in cases, even if there's a hearing set in a DNA case, as long as you get permission to speak to a parent, you have a right to talk to them. Now, any defense attorney worth his or her weight in salt, if there's a criminal case pending, will tell their clients not to speak to anyone, including CASAs. I wouldn't take that as an insult. That's just good lawyering, because you don't want something said that could be used against them criminally. All right. There we go. You cannot file appellate briefs, by the way. CASAs cannot file briefs, which is good because they're not a lot of fun to write. Also, you can, however, provide the court with lots of information, if permissible, through the Kentucky Rules of Evidence. All that means is, if there's not some sort of hearsay, if there's a hearsay exception or hearsay is not at play, you guys can, you all can provide the court with all sorts of information. You guys are a lot like my job. I'm the friend of the court here in Fayette County, and I supervise 4 master's level social workers, and we do all sorts of risk assessments and custody assessments and evaluations. And I feel like all I do, I interview kids constantly, and I'm a professional tattler, because I had to tattle and say what the child said. And so unfortunately, sometimes the parents get to see what the child says, and there's sometimes unfortunate ramifications for that. But that's the deal. And that's the reason why the Supreme Court got involved, is traditionally you'd have a guardian ad litem who knew that they represented the child. However, they also were sort of an extension of the court. That was what some cases called them, and that they had a duty to inform the court about what's going on, of what their investigation is. And the Supreme Court basically said, hey, you can't have those dual roles. Either represent the kid or be a tattletale for the court. So, in front of the courts and us, we advocate for the best interests of the children, but our job is to inform the court. We're an investigative arm for the court, so the court has all the information in front of them to make the best decision possible. All right, next page, please. This was always one of my favorites, because who does the county attorney represent? And this is, to be honest with you, this is the question I get asked most when I train by folks who work at the county attorney's office and all sorts of courts. And here's the deal. Does the prosecutor represent the Cabinet for Health and Family Services in a DNA proceeding? Next slide. It seems like they do, but they don't. They do not. The county represents the Commonwealth of Kentucky. Cabinet happens to be also a representative of the Commonwealth of Kentucky, but the Cabinet has attorneys. If the Cabinet wants to bring in attorneys to DNA cases, which they occasionally did over the 23 and a half years I did these cases, they have a right to do that. They certainly can. But KRS 69.210 says that in each county, it's the county attorney's job to prosecute all cases in the juvenile division of the district court. And that's just old language for juvenile division of the district court is turned into family court, and it's DNA court. So it's the county's job to prosecute those cases. And I know lots of folks on here from different areas, and it's so weird how our state is. I know we go to counties where the Cabinet calls all the shots. I know I've been to counties where the prosecutor calls every single shot. Nothing happens, seemingly. The judge doesn't even realize that the county attorney is not in charge. But I promise you, this is what the law says. The law says it's the county's job to do it. All right. All right. Next slide, please. Here's a good one for you. Does the CASA have immunity from civil liability in DNA cases? Next slide. When I was actually updating the guardian ad litem training curriculum for the state of Kentucky, and I came upon some cases that made me feel a lot better. And that is this. Basically, guardian ad litems, and I believe that CASAs as well, and certainly friend of the courts, it says witnesses and other persons who are integral parts of the judicial process are entitled to absolute immunity. I like absolute immunity. It helps me sleep better at night. So what is an integral part of the judicial process? Well, there's a Sixth Circuit case, the next bullet point, which Sixth Circuit, by the way, is the Federal Court of Appeals, which includes Kentucky. It says guardian ad litems are entitled to what's called Briscoe immunity. You'll notice that case above it is Briscoe versus LaHue. It says guardians and ad litems are entitled to Briscoe immunity because their position makes him or her an integral part of the judicial process. That case went on to say a guardian must be able to function without the worry of possible later harassment and intimidation from dissatisfied parents. So I'll tell you what, I think the easiest argument I could make as an attorney is to convince a judge that a CASA who is acting in good faith is also an integral part of the judicial process and should be entitled to absolute immunity. I'll tell you what we do now when we get appointed in my county, my staff gets appointed as the friend of the court. I have rewritten the order which appoints us, and not surprisingly, I write in there that we are being appointed as an integral part of the judicial process and are therefore entitled to absolute immunity under Briscoe versus LaHue, 480 United States 325. And we haven't even got a complaint since we put that in there. And I think that's real important. Now, if you guys do something, if somebody of your CASAs does something unethical, that's a different ballgame. But if all you're doing is doing the best you can, and you believe that what you're doing is in the child's best interest, some parent is not going to be able to successfully sue you because of this case. So anyway, in any event, I think you need to, if you have an appointment order, you might want to consider throwing in an integral part of the judicial process because that automatically triggers it. And you'll have, before the case even starts, a judicial finding that you're entitled to absolute immunity, which I actually think that's a great deal. Next slide, please. And tips about being a better CASA. And I've always thought, and I've done a lot of trainings here in Fayette County for CASA. I think I do about 4 a year that they sucker me into coming down on Saturdays for, which is fine because they give you really good snacks. But in any event, it's important, I think, to provide, to have a positive relationship with all of the court players. The guardian ad litems, basically the guardian ad litem is doing the same thing you are. They can just make motions. I think it's really important for you to talk to the guardian ad litem. He or she may have information that you need, but more likely, I think you may have information that they may need. And other court and community partners. I mean, I don't have a problem with it. I loved it when CASAs would talk to the parents' attorneys as well. And as a parent attorney, I remember it's been a long time since I was a parent attorney, but I was in the early 90s. And I always, it was a lot easier to speak to your client, the parent, and say, I think you need to stipulate to abuse or neglect if you've got ammunition that you can do that with. So I think it's important. I mean, obviously, you're going to get more flies with honey than vinegar. You don't want to put your hand on your hip and scream at anyone, but you absolutely, I think we all need to be professionals and say, hey, I think you need to know this. Is there something that, can I talk to you? I think that they will do that. Also, community partners. I think obviously the social workers need to have contact with you. Hopefully they are also doing an investigation and you all can share information back and forth. I hope you have a good relationship with your with your CASAs. Next page. I mean, with your cabinet. All right, and I think it's important that you know the key differences between guardian ad litems and CASAs. They both advocate for the best interest, although they got those key differences. Parents, attorneys can be interviewed. Just remember that you need the attorney for the parent's permission to interview the parent. I think that's important. And always speak to the cabinet social worker if possible. I'll tell you throughout the years, who I've gotten just incredible information from are children's teachers. They know so much more, and sometimes they feel so frustrated that they can't do anything. Sometimes they call things into the cabinet that don't get accepted. So I think schools, teachers, and counselors and principals provide unbelievable wealth of information that could really help the kid who you're trying to help. Next slide, if there is one. Oh, questions. There you go. Sorry about that. I thought we'd take about a half an hour figuring that stuff out. And if we have any questions, I would love to talk about this.
Duane, I have not seen any questions come through in the chat area, but just as a reminder to everyone, if you do have questions, go ahead and type them into that chat area there. Or if you've asked if you've asked Della, I don't know if you've gotten any questions, if you want to say anything, or if you have any as well.
Me okay, Brittany? I am trying to talk. Can you hear me?
Yes, I can hear you. Yep.
Oh, great. I did have a question. Duane, thank you so much. First, let me just say that I think this has just been super educational, definitely for me, and I hope for others on the call. One question I did have is, you mentioned that the CASAs need the parent's attorney's permission before they can interview the parents. I wonder if you could talk about that a little bit, and let me tell you why I'm asking. Lots of times courts will just direct the parents to cooperate with the CASA, and largely that may mean allow access to the child, because that's what we have to be able to do, right? If the child is still living at home with the parent, for instance. But and obviously an attorney can direct their client not to talk with the CASA. But are you saying that before the CASA can even talk with the parent, they need the parent's attorney's permission? And why would that be? They're not attorneys, so I'm interested in hearing why would that be.
I think that's a great point, and probably what a better way for me to have said that would be, realize that a parent may not be able to talk to you. I think that. And you know what? Here, I'm sort of used to a little myopic here. I deal in Fayette County where everyone stays in a room, and the CASAs will be talking to the parents' attorney saying, "Hey, I need to see your client. Do you have a problem with that?" That's kind of what happens in our county. But I realize in most counties you're probably just going to have a judge say to cooperate with CASA. You're absolutely correct. I'll tell you that. I think a better way for me to have said it would be, don't be upset if you don't get to speak to the parent. Hopefully, and you are right, CASAs are generally not attorneys. It is up to the parent's attorneys to advise their client, the parent, don't talk to the CASA or anyone without me present. So thanks for giving me a chance to straighten that out.
Thanks, I appreciate it. I'm counting to 10 to give other people a chance to see if they have any questions. That's part of our facilitator training, Duane. We're supposed to count to 10 to make sure.
Well, I try to teach my 3-year-old that as well before she explodes. So that's really good.
Let me ask you, it feels like with Morgan v. Getter, and it's not a far stretch to eventually realize that those parameters that were put on a GAL's ability to testify, which now they can't do, make reports and recommendations and so forth, it's only a matter of time before that's expressly applied to DNA cases by a court. Do you feel like that is going to that increases the need for CASAs or friends of the court like you, if the GAL's ability is really more in the court proceedings to function just as a pure attorney on behalf of the child?
That's a great point, and the answer to that is yes. And first of all, Kentucky court systems are so weird. We've already had cases that have said that the Court of Appeals has said that they said exactly that this premise is going to apply to DNA cases. The reason you don't know about those is they were ordered not to be published. There's a really weird phenomenon in Kentucky appellate law. Half of our cases they choose to publish, half they choose to not publish. When they don't publish them, you're not allowed to even you're not even allowed to reference them. But you know, and I to this day we joke about attorneys joke about that and say, who, you know, they're going to flip a coin and figure out which one that they're going to which one is published and which one is unpublished. But regardless, there's been several cases already, and I actually used those cases at the judicial conference and said, here's 4 cases that have already been used after Morgan versus Getter. There are 4 appeals from DNA court, and every time the Court of Appeals said, yeah, you have to respect Morgan versus Getter in DNA proceedings, but then they ordered it not published, so we can't even talk about it. There's also an attorney general opinion out of Jessamine County, where a judge in Jessamine County ordered an attorney who was a guardian ad litem in a DNA case to write a report. And this guy had been to one of our trainings, and he asked for an ethics opinion from the Kentucky Bar Association and said, hey, this guy just told me I can't write a report, and the judge just ordered me to write a report in a DNA case. And the Kentucky Bar Association came back and said, you can't write it, because Morgan versus Getter says you can't write it. That being said, it's real obvious that it's going to head to DNA court. And as a result, I wish we had CASAs on every case, on every removal in the state of Kentucky, because you were exactly right. It will definitely hinder the guardian ad litem from doing that, advocating.
Thank you. Does anybody else have any questions? Okay, then. Brittany, do you have anything you want to say before we close up here?
Just another quick note. I think that there were a couple of people who joined late. So if you were one of those people, if you could just make sure that you type in your name and your program into the chat area. That way we make sure that we have everyone documented there. And we did just get one question on there, Duane. So we'll go ahead. If
how many counties has the friend of the court model? Well, here's the deal. The CASA is set up like a friend of the court. So I would argue that in DNA court, any court you've got CASA in, you've got a friend of the court. But as far as what I do, we actually have a friend of the court office here in Fayette County. And we are one of, I think, 2 or 3 out of the 120 counties that have those, because we have separate funding. We're funded by the city of Lexington, not funded by the administrative office of the courts. But I think that this applies. I mean, I think even if you don't have a friend of the court's office, in all of these other counties, we are seeing hundreds of judges appointing FOCs, or friend of the courts, or sometimes they call them de facto friend of the court, in all sorts of family court proceedings. Even I was stunned when I went to the judicial conference, because I asked them, do any of you appoint friend of the courts in DNA cases? And there was a handful who do that now. So the Morgan versus Getter is supposed to cover the entire state. If you're asking just how many FOC offices are there throughout the state, it's like 2 or 3. If you're asking, does the FOC model, is it now in the family courts, I would say yes, it's in all 120 counties for family court. Is it in DNA court specifically? I'm going to say if you've got CASA, I think that's exactly an FOC model. So, this is really something that is just, we're all just kind of watching it progress. And, it's government, so it's not happening quickly. But because this case was decided 4 years ago, and we're still trying to figure it out. But so the answer is, I mean, this model is supposed to work in all 120 counties. It hasn't specifically been ordered that you have to do it in DNA cases, but we already have counties who are jumping the gun and who are doing that. I hope that answers it. Oh, here we go. You said a CASA has the right to notice the court hearings. What can we do if we're not? Is there any recourse? I mean, there's no good recourse. The next time you get to court, you can embarrass the clerk and say, I did not get notice for this. I certainly would have been here had had the clerk sent notice. But it's absolutely the clerk's duty to send you guys notice, and that's something that I used to hear about doing trainings, even for garden ad litem's, they would not get notice. I don't know of anything else. Is there any punishment for not getting notice? Not that I'm aware of. Yeah. But that's a huge.
Stella, so one of the, like you say, it's actually the clerk's obligation to make sure they send all the interested people notice of the hearings and what's happening.
Absolutely.
So,
yeah.
So they could, so the supervisors could go talk with the clerk at the court clerk's office, right, and say, I didn't get notice on this, please put us on the service list, right? They could do that to make sure it's on the service list.
Absolutely. I would be as nice as possible, because these people make no money, although I shouldn't say that to a bunch of volunteers. But they make very little money. They get yelled at a lot by parents. But yes, I think you need to ask and say, we need to get notice of everything. And, if you need to talk to the clerk, whoever he or she is in your county, to get that done, do that. But yes, that's perfect. I would go and talk to the clerk and just say, what do we need to do to make sure we get notice? I think that's the best you can do is try to fix it for the future. I don't know any way to fix it after it's happened.
And I'll just add, and you would not necessarily know this, Duane, sometimes this comes up when there's a little question about, has there actually been a CASA appointed yet, right? So once you get your CASA appointed versus, you're not going to get notice of every hearing for all DNA cases, but on the cases where you've had your volunteer appointed by the court, then you should be on the service list getting the notices then.
Right. Right. It's less of a problem in the bigger counties, and I know that most of you guys are not in the bigger counties, but like we have a CASA supervisor in every DNA court. So sometimes if they forget to get notice, there's at least someone from CASA in the courtroom who hears that. So we have less problems. But obviously, if that's not your model, and that's very few counties can do that. I would think that would drive me nuts. I mean, I love a party, but you need to be invited to the party,
All right, Brittany, did you see any more questions?
I was asking you, when is your all's annual meeting?
We're having our conference this September.
Okay.
I have to look at my calendar. It is September the 19th, and it's in Louisville. At the Omni Hotel.
I think those. How awesome! Good for you all.
All right. Anything else, anyone?
Well, I'd like to thank Della and Brittany. You all have made it really easy to do this, and I appreciate you contacting me. I enjoy talking about this, and hopefully, you all learned at least one thing. I know I did. So, thank you, Della.
Well, thank you, Duane. I just think, like I said, I think it's been fantastic, and I'm so happy you did this. We appreciate your time putting this all together, and we will have this available to programs. We appreciate you letting us do that so that they can have staff watch it at a later date if they need to, and reference this to make sure they're fully informed about how a GAL and a CASA, what they are like and how they're different and how it all works. I think this has been just really, really helpful. Thank you so much.
Good.
All right. Thank you, everyone. Have a great rest of your Monday.
Thank you.
Thanks, everyone. Thanks. Bye.
Bye.
All right. Thank you all.